Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. So, we received an interesting inquiry here on our YouTube channel. This has to do with somebody who got accused of refusing a DUI chemical test. Let's see here. I was stopped for driving under the influence. After they arrested me, I was taken to jail and I refused to take the blood test or to blow. The police insisted that I did not have the right to refuse, but I ignored it. I have been told that my situation is worse now. Yes, let me explain. Usually, when you are stopped for any kind of traffic infraction or driving suspiciously, that will be probable cause for the police officer to begin an investigation for DUI, driving under the influence of alcohol or drugs. Now, if he smells alcohol or he sees that you're acting erratically, he may think that you're under the influence of alcohol or drugs, and he will ask to do a set of field sobriety tests. Now, at that point, you haven't yet been arrested. You have only been detained. Now, because you have not yet been arrested, you've only been detained, you do have the right, you have the legal right to refuse to do the field sobriety tests. Remember, this is only at the point where you have been detained, not arrested. You know, the horizontal gaze nystagmus, the finger count, doing this, all this stuff, you have the right to refuse it, including blowing into the pass device. However, once the police officer has arrested you, you are now under arrest for DUI. He'll either take you to the station or to a hospital or to local jail, depending on his prerogative. Now, at that point, now that you have been arrested, you no longer have the right to refuse a chemical test. You have to give blood, breath, or urine. If you refuse, they will first read you something called a trombetta advisement, letting you know that while you're on the road, you have given law enforcement implied consent to where they have the right to get a blood result from you or a breath result. You basically have to submit yourself to a chemical test. If you refuse at that point, you're basically going to get an automatic DUI. That's it. Game over. Sometimes the police will get a warrant to get the blood extracted out of you, but they don't necessarily have to do it. Once you refuse, that's it. It's over. You're getting the DUI. You don't have the right to refuse. The DAs love it when people refuse the chemical test at the jail, because they basically don't have to show, they don't have to prove that the alcohol was impeding your ability to safely operate the motor vehicle, or that you had a blood alcohol level of a 0.08 or more at the time of the drive. They don't have to prove any of that stuff once you have refused. And not only that, but if you refuse a chemical test after an arrest, the DMV will suspend your license for an entire year without the ability to obtain a restricted license. So yes, absolutely, if you refuse a chemical test after your arrest, you will in fact have made your situation worse. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. But if you've been accused of a crime here in the San Francisco Bay Area and need representation in court, give us a call for a free consultation at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who wants to run from the law because he's afraid of being investigated. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorneys.